Okay.
Good evening to all of you. My name is Jeanette Haregi, and I'd like to welcome you to the Ventura County Area Agency on Aging's seminars on brain health and wellness. The seminars are a series of informational presentations designed to provide critical resources for Ventura County residents living with a dementia-related disease and their caregivers. We are excited to welcome all Ventura County residents who are interested in learning more about navigating local services targeted at optimizing quality of life. The seminars on brain health and wellness were inspired by the VCAA's Advisory Council's commitment to making critical resources more accessible to older adults, people with disabilities, and their caregivers. Here to introduce tonight's presentation is Maureen Hodge, High Risk Manager for Community Memorial Health Systems and member of the VCAA's Advisory Council. Maureen, I will pass it along to you.
Thank you, Jeanette. Well, we're really happy to be here. I'm so thankful for all of you who could join us today. This is great. So we're really excited to invite Christopher Young. He is an attorney with the Alvarez firm in Camarillo. He is a California Bar Certified Specialist in estate planning, trust, and probate law, as well as related litigation. He's become a better estate planner by seeing where planning mistakes are commonly made and fought over by families. In 2022, Chris was selected by his peers as a Southern California super lawyer for his work in estate planning and elder law. He is originally from the Portland area and remains licensed to practice in Oregon, but relocated to California in 2012 to be closer to family in this area. He's also an accredited attorney with the U.S. Department of Veterans Affairs and organizes a local senior law clinic where more than a dozen attorneys volunteer on a rotating basis to offer free consultations to seniors each Monday afternoon. He also, this is so interesting, played violin since age 4, and though he doesn't have much time to play these days, he still pulls out his fiddle for family and friends when asked. I wish you brought it, Chris. He and his wife, Sarah, live in Ventura County with their young children, and Chris, we're so glad you're here. Thank you so much, and I know we have some participants joining, but the floor is yours, and I'm really excited you're here. So,
thank you very much, Maureen and Jeanette. I'm going to share my screen. All right. Hopefully this works. Let me know. Did that work for you guys?
Yes, that works.
We can see it.
Okay, perfect. And I one of the things we talked about, Maureen, is if there's questions, I want to encourage people to ask questions. If there are questions, please type them into the chat. And Maureen will interrupt me if it's appropriate, if it's on the topic, and ask me that question. I want this to be, to the extent we can in a webinar, as much give and take as possible. So happy to do that. So this presentation, I just called it Legal Tips for Dependent Adults and Their Families. And a dependent adult is really somebody who has something that makes them dependent on other people. And in many cases, it's memory issues, it's dementia that's setting in. And so those people are often senior citizens as well, but it's not just seniors. And we'll talk about in a second, elder law and why that may be not the best name, because there's people that are not seniors that still need this area of law. But as Maureen mentioned, I'm with the Alvarez firm. We practice elder law, special needs planning, probate and trust administration, litigation, to resolve trust and probate disputes when that's necessary. We also have attorneys that handle business and real estate transactions and litigation. And we have offices here in Camarillo where I practice and live, but also in Westlake Village, Calabasas, and recently opened one in San Juan Capistrano. As Maureen mentioned, I am a certified specialist in estate planning, trust, and probate law, and my peers have elected me to be a super lawyer. So that was a compliment. So we mentioned that. And also, as Maureen mentioned, I've played violin since I was age 4. A lot of people ask when I get to the end of her presentation, who are you again? So I mentioned a few things like this. My parents, in all candor, my parents heard me sing and they said, that's just not going to work. So they got me violin lessons. I am from the Portland area, City of Roses. That's Mount Hood right there. But this lovely lady, my wife, Sarah, is from this area, Ventura County. So we are down here to be closer to her family, and those are our 5 kiddos. So I wanted to start this presentation, have it kind of in having 5 kids, I'm familiar with tests and pop quizzes, and so have kind of a true or false presentation or format here. So we're going to start with some true or false questions. And again, if you have questions about what we're talking about, please feel free to jump in through the chat. But the first true or false question, and one that's on a lot of people's minds when they're looking at brain wellness and issues that come up later in life, is whether a diagnosis of dementia prevents a person from signing legal documents. This is something I see all the time in my practice and get asked very frequently. And the answer to that is false. And that surprises some people. But the fact is that dementia and Alzheimer's dementia and other forms of dementia are not a light switch. It's not just on and then off. There are plenty of people who have been diagnosed with dementia who can still sign legal documents. And there are plenty of people who haven't been diagnosed that really have no business signing legal documents for whatever reason. But it's not the diagnosis that impacts this. And I just want to touch on the actual law in California. We have a very helpful probate code in California. It's very easy to read. And probate code section 810 talks about this, and it's very readable. And it basically starts by saying, look, there's a presumption. It's rebuttable, which means that there can be proof to the contrary. But there's a presumption that everybody has the capacity to make decisions and to be responsible for their acts and decisions. So that's the presumption. We always start with the presumption that you have the ability to do these things. But what if there's an issue? What if there's been a diagnosis? Well, somebody who has a mental or physical disorder may still be capable of doing all these things: contracting, marrying, making medical decisions, executing wills and trusts, and doing other things, right? So, and when a judge is looking at this, they are going to look at all sorts of factors and not just whether there's been a diagnosis or not. So a judicial determination, see the red section, should not be based on evidence of should be based on evidence of a deficit in one or more of the person's mental functions, not on a diagnosis. So if you're talking to your friends, if you're talking to your family members, or if it's you yourself that's impacted and you get a diagnosis, that does not mean that everything's over and you can't do anything. What it really means is now's the time to make sure things are done that you might not have gotten to. All right. So conversely, Probate Code 812 says that a person lacks the capacity to make a decision unless, and this really is where the rubber meets the road when somebody comes to my office and wants to execute an estate plan, for instance, unless they have the ability to communicate verbally or by any other means the decision that they're about to make, and they understand and appreciate to the extent relevant all of the following. And these are the factors, these are the things they have to be able to understand and appreciate and communicate verbally or by some other means back to the attorney. The rights, duties, and responsibilities created by or affected by their decision, the consequences, the probable consequences for them and for other people that are impacted by their decision, and the significant risks, benefits, and reasonable alternatives involved in the decision. This is part of any decision that any of us might make. But these are the factors that an attorney or a judge would look at to decide whether the person had the capacity to make a legal decision or to sign a legal document. And I want to ask you, if you see one particular word in any of this, does it say remember? And the answer is no. It doesn't say that they must remember it. So memory issues are very common, and sometimes people forget. Something very, it doesn't even have to do necessarily with dementia. We forget things. And we don't necessarily have to remember what we did later, but we have to know in the moment what it is that we're doing, why. So, and like I said, I'm an elder law attorney. Elder law is a subset of estate planning, or estate planning is a subset of elder law, depending on who you asked. But the fact is that we look at these issues regardless of age. They can impact people of any age. So it's kind of a poorly named area of law, but these issues can come up for younger people in the middle age, and certainly seniors as they progress in dementia and whatnot. I have another, if there's no questions right now, I'll have another true or false question here for you. Question 2, true or false, every adult should have an advanced healthcare directive. This is kind of a gimme, but the answer is yes, every adult. The moment you turn 18, your parents have lost the ability to just automatically make decisions, medical decisions for you. I was in court earlier today helping a family whose developmentally disabled son turned 18 a few weeks ago. And so we were able to help get them appointed his conservator. And we'll talk about conservatorships in a bit. But the point was that wasn't automatic. And if you have the capacity to execute an advanced healthcare directive, you really should. Let's talk about what that is. Notice for first, and this is a common question or issue, is people often put a D at the end of advanced, and they think it's an advanced healthcare directive, like a really, really high quality one. But no, all it is advanced, meaning we're telling people what we want to have done in our end of life decisions or in our medical decision making in advance. So that's what an advanced healthcare directive is. There's 2 main players in and let me just say one more thing about it. There used to be 2 documents that are now combined in an advanced directive: a medical power of attorney for healthcare, or a power of attorney for healthcare, and a living will. And both of those documents were very poorly named because living wills were confused with regular wills for people when they pass away. And power of attorney for healthcare was confused with powers of attorney for finances, which are the much more common ones that people think of. So both of those documents were combined about 20 years ago into the single document now with the advanced healthcare directive. So like I said, there's 2 main players. There's a principal and there's an agent. The principal is the person who gives the power to make decisions, and the agent's the one receiving the power who will act with that power. This document is a way to let your wishes be known. And some of the things you can do are naming your agent, naming the person who's going to make decisions for you, designating your end of life care, governing things like organ donation. That's a big issue that can be done with stipulations about what can and can't be donated, and things like that can be done through your advanced healthcare directive. Now, what happens if we don't have an advanced directive? Unfortunately, it often becomes who's the loudest person in the waiting room. And that's just because of the reality of oftentimes we have more than one child. And if the children are all sitting in the waiting room, the one that is going to be the squeakiest hinge is the one who's going to be listened to more. This is human nature. So if you think that the person who's the loudest, squeakiest hinge might not be the one who you want making decisions, it's all the more reason to make sure you have the agent that you want nominated. Typically, if you don't have one of these, an advanced directive or a conservator, we're going to look for the nearest adult relative that you might have. So if you don't have this, we'll look. The easy answer, of course, is a spouse. But if you have no living or a spouse or one who can make decisions for you, then we do look at children. And again, if you have more than one child, then you have the potential for a conflict. Not all advanced healthcare directives are the same. There are forms that are available through the state, which essentially are better than not having one at all. They're pre-printed, but they do leave much to be desired. There's some lines where you can fill in what you want. There's usually 2 paragraphs regarding end-of-life care, and you would initial next to one of them. And again, it's better than not having something at all. But if you summed up those 2 paragraphs, you could sum them up as pull the plug or spare no expense. And most clients that come to my office are somewhere in between. They have more nuanced opinions about what they would want in their end-of-life decision-making, somewhere between those 2 extremes. An attorney-drafted advanced healthcare directive allows for more of those options. And a question I hear a lot is, what about a POLST? A POLST stands for a physician's order for life-sustaining treatment. And it came actually out of my home state of Oregon, out of the Oregon Health and Sciences University a while back in the 90s. It's primarily for for terminally ill patients who are approaching the end of life and do not want to have heroic measures taken. There are some, it is, I'll just say this, it serves a purpose, but it does not replace an advanced directive. So if you want to be naming agents, if you want to be going into detail about what it is you want and do not want, the advanced directive is going to be the way to go. So I've got any questions, Maureen, on anything we've covered so far?
I don't have any questions in the Q&A.
Okay, very good. So we'll keep moving along. The question 3 that I have here is true or false. If you are incapacitated, your spouse or child can make financial decisions on your behalf. And that one is false. Now, there's a little bit of a trick to that question because we do live in a community property state. So community property can be controlled by a spouse, but there are even exceptions to that. And first of all, I'll just mention the difference between community property and separate property for anybody who has a question about that. Community property is property that you come into during a marriage. So it's property that was earned or purchased by you during your marriage usually with your spouse in some role, either active or passive. Property that you obtain by gift or inheritance or that you bring into a marriage, that is separate property. So we don't need to talk more about that right now, but community property in principle can be managed by your spouse. Here's a reality though. Oftentimes our retirement accounts, almost always our retirement accounts are in the name of just one spouse, even though those are community property. Because obviously, we work during our marriage and that our spouse has a rights to the income and the retirement assets that we earn, but because of the nature of a retirement account, it is in the name of just one spouse. So there is no simple mechanism to make sure even community property can be managed by your other spouse, the other spouse. And so what often happens, well, let me just say this, here's a follow-up question. I would just say 3B, a durable power of attorney is the most important document one needs in the estate plan. And I'm going to say yes. It's one of the simplest, cheapest documents that you can have an attorney draft up. And it's also one of the most important because it avoids, in many cases, the need to go to court and sometimes even obtain a conservatorship over one's own spouse. And I can go into more detail when we get to that, but what you can avoid with a power of attorney is and give you the ability, so give that spouse the ability to manage a retirement account without needing to go to court and get permission. So let's talk a little bit about financial powers of attorney, which again, if we're looking at aging issues, if we're looking at the possible dementia, a diagnosis, maybe a progression, one thing we know about this is it doesn't get better. So this is the time, if you're thinking about these things, to act and to get these documents in order and to prepare for what's coming and be as ready as possible. So financial power of attorney also has the same main players as an advanced directive. There's a principal and an agent. There is a statutory form. Again, like the state form with the advanced directive, it is a very simple form, and I'll show you a picture of it in a second. The best pro in favor of having that form is that it's free. It's written out word for word in the probate code. So that can be a very helpful thing, and that you don't have to pay anybody to do it. A con that I find is that it's too general. It doesn't necessarily include all the things we'd want, and there's some drawbacks to it. But it is like the advanced directive, the statutory, it is better than not having anything at all. And let's talk a little more about the advantages and disadvantages. A state statutory power of attorney that comes to me in my office often reminds me of a pocket knife. It's got a blade on there. It can open gift wrap and a bank account, but it can't necessarily do much more than that. An elder law attorney who prepares a power of attorney is going to prepare something that looks a little more like this. And you may never need the wine opener or the toothpick, but if you do, and it's there, you're glad you have it. So this is the elder law version of a power of attorney. And what I mean specifically is we look at the statutory form power of attorney. This is what it looks like. Many of us have seen one. It just has a fill in the blank. You can say who you are and who you appoint. It's immediate. And then you can initial next to A through N. A through M are specific powers that you might have, that you might want to give to your agent. And N is to give all the powers listed above. So you can initial just once on N and cover all of those powers. And frankly, that's what most people do. But there are things that are not on this form. One of them has to do with estate planning. So if we have an estate plan, or if we give gifts to people, say we give charitable gifts or gifts at church, in the collection, those types of things, your agent is not authorized to do on your behalf in a state statutory form. So these are common things that come up that you need to have something more than this to be able to have for your agent to accomplish. So let's talk a little bit about the mechanics and how they work. There are a couple of terms you'll see having to do with powers of attorney. One is durable versus non-durable, and the other is springing versus effective immediately. I mentioned a moment ago that the state form is immediately effective. Durable means the principal must have capacity. I'm sorry, the durable has to do with capacity. And if it says it's durable, it means the principal, it continues on even if the principal has lost capacity. Non-durable means the principal must have capacity when it's being used. And you might ask, why would there ever be a non-durable power of attorney? Well, the power of attorney has to actually say that it's durable for it to work. So you have to include that language. If you have a power of attorney, look at it, take a look at it, make sure it does say that it's durable and that it continues on after the principal loses capacity. There may be times where you do a temporary power of attorney for a specific purpose, and you might not use that language. But for the vast majority of people, you're going to want a durable power of attorney. Springing versus immediately effective or effective immediately is what it sounds like. Something must happen to activate a power of attorney if it's springing. Usually it's the loss of capacity, and there's evidence as to what constitutes that and what the trigger is. And immediately effective is just what it sounds like. When you sign it, it's in effect, and your agent can start acting for you. You might say, well, why would I want a power of attorney that's immediately effective? That actually can be very useful. You don't necessarily have to, you're asking a lot of your agent to help you. And if you also then make it springing, you're asking them to also prove to third parties that you are incapacitated. Whereas if you make it immediate, they can just go and use it as needed, and they don't have to get doctors to sign or whatever the springing trigger might be to prove that you're incapacitated. The other advantage is that if you've got your capacity and they're acting for you, and you don't like what they're doing, then you can fire them. You can do a new one and appoint someone else. So that's okay. So many people have immediately effective powers of attorney. Like I said, the state statutory form is immediately effective, but also a great number of people have springing, and they feel better about that, and that's fine. But if you want to reconsider, take a look at what you have right now. If you have one, you might want to change what you have depending on what we just talked about. Again, I find it simpler for the people you're asking to help you if it's not springing, because sometimes it's hard to get doctor's letters. Especially a lot of them ask for 2 doctors, and they ask for it to be under oath and all sorts of things. And that can be a big ask, especially where there's managed care and there's just a primary doctor. So these are things to consider as you're asking people to help you. So advantages of a financial power of attorney: they are private, flexible, very cheap to make. They can go into effect immediately, like we've been talking about. They can eliminate the need for a conservatorship, and we're going to talk about that in a second. But that's a big thing because conservatorship can be very expensive and time-consuming and quite a process. It allows management on a trial basis. Like I said, you can fire somebody and put somebody else in if you want. You don't have to transfer title like a trust. You can just they can go to the bank and say, I'm agent under the power of attorney. and no title has to change on the accounts. And it can be used if you have the right powers in there to create and fund trusts. So that's something having to do with estate planning that can be done. There are disadvantages, though. You hear of a lot of fraud when it comes to powers of attorney, and there's a lot of skepticism because of that among banks and third parties that you ask to honor a power of attorney. Many of them decline because there's so much fraud out there. So the third party must be willing to accept the power of attorney. And I would say that's the single biggest issue and disadvantage of a power of attorney, is that some third parties just won't. My understanding is that reverse mortgage companies, when you apply for one, they want to have some contemporary evidence from the time that the power of attorney was made that there was capacity. Well, again, that's basically asking to go back and show all the things that under probate code 812 that they understood what they were doing and all of that, but sometimes many years have passed and that was never obtained. So that can be very difficult. Power of attorney may not be fully understood by the principal or the agent. The agent may be unable to gift to themselves, and you might say, well, that's a good thing, and oftentimes it is. But what if the agent is a relative that you would want to be able to receive a gift of your assets if needed? So the default in the law is that they can't do that. So it has to be spelled out in the power of attorney. Accountings are not automatic. Why would we want an accounting? Again, to just keep an eye on things, to make sure there's nothing wrong that's going on. Nobody's taking money they shouldn't be taking. Along the same lines is there's no court supervision. You want with a power of attorney, you would you got to make sure you appoint someone that you trust, so that there's going to be so that we aren't in a situation where there's going to be fraud. And here it's an interesting one. This last one, the principal still retains the authority to act, and sometimes to their detriment. So if somebody is losing capacity, and their agent or the power of attorney is trying to help them, but they're actively working against their own interests by perhaps opening new accounts and moving money and then forgetting where they put it. These are real cases that I've dealt with. That can become a real issue. And so what do you do in that case? And this is why I've alluded to it a lot, but sometimes you just have to go to court. And the court process for addressing issues like this is called conservatorship. It's when a power of attorney or an advanced healthcare directive are missing, or when they're not enough. A lot of people ask me what the difference is between a power of attorney and a conservatorship. Power of attorney, you're sharing your authority. You're giving someone else the authority to act, but you never lose that authority. In the conservatorship, you do lose the authority. The court takes it from you and gives it to someone else. And that's a civil rights issue. We have to be very, very careful that we know what we're doing and we're respecting the person whose rights are being affected, but trying to help them. And the court takes that very seriously. And so that's part of the reason it's such a process and such a chore and so expensive and involves court hearings and things like that, is because the court's going to make sure that things are done correctly to the extent it possibly can. So that's, if you've ever wondered what's the difference, sharing of authority under the agency documents and a taking of authority, investing it in another person under conservatorship. There are three main types of conservatorship. The one that most people think of is called probate conservatorship. Then there's something called limited conservatorship, and we'll talk about each of these. And then there's something called LPS conservatorship. So probate conservatorship is when somebody is getting on in years and they don't have the power of attorney or the healthcare directive. They need the assistance, or the power of attorney and healthcare directive aren't enough, and they need the assistance through court. So there's a couple of kinds. There's something called conservatorship of the person, which is making this, that the conservator of the person makes decisions regarding where a person lives, where they're educated, what medical decisions on their behalf, anything like that. And then conservatorship of the estate, as it sounds, has to do with protecting the assets of the person. This is most often used when adults become incapacitated later in life. Both of these, person and estate, can be obtained on a quick basis. I say quick, here in Ventura County, it can still take a couple of weeks unless there's a real emergency, and then the court can try to serve you in a day or two. Or they can be what's called general, which is basically a permanent situation. Limited conservatorship is what I was in court for earlier today, and it has to do with developmentally disabled adults. It differs from probate conservatorship in that rather than taking away rights, generally rights to make these decisions, it takes away one of up to 7 specific types of powers that a person might have. The powers to contract or to decide whether to marry, things like that. So it's a much more restrained, more, just as it sounds, limited form of conservatorship, specifically for younger people that might improve over time and maybe not have to have this any longer. And an LPS conservatorship is for those who are gravely disabled, a danger to themselves or others. Often you hear the term 5150. If they're on a mental health hold, the county may, working with the hospital, establish this type of conservatorship to help them keep them safe from themselves and keep others safe as well. So those are the types of conservatorship. It's a drawn out process no matter what. It's expensive, but it's there if we need it. And so, and my office certainly helps people when that time comes. One more true or false question. This is kind of moving into some of the how do I get public benefits territory, and this may be something that's on your mind. True or false, if you are on Medi-Cal and you own a home, Medi-Cal will take the home at your death. This is a very common belief by people. And generally speaking, the answer is no, but there's a catch. If it's just sitting in your own name and you've been on Medi-Cal and you die and there's a probate of your home to get it to your heirs or your beneficiaries, whomever they may be, then the court will require that notice be sent to the Department of Healthcare Services asking if there's a bill to pay. So in that sense, some of your home, some value may be taken to pay back that bill. But this is a narrow thing. And in California, Medi-Cal estate recovery, this is the part that comes back and gets assets back that were spent on someone while they were on the Medi-Cal program. It only applies in California to benefits received on or after a 55th birthday. They must be in the name of the person who was receiving benefits at their death. And as I alluded to a minute ago, as of January 1st, 2017, repayment is only on assets subject to probate that were owned by the deceased Medi-Cal recipient at their time of death. So how do we avoid that? The most common way, and you might see it coming, is through a living trust. If it goes through a living trust, or there's some other ways, there's something called a transfer on death deed. If you can get assets out to their beneficiaries some way other than probate, they will not go back to the state when the person dies. So this is a change in California. I've practiced in 3 states, and this is the only one of those 3 states that I'm aware of. And frankly, it's the only state in the country that I'm aware of where things are quite so flexible when someone passes away. Oftentimes the state will go after those assets aggressively, even if they're in a trust. Follow-up question, true or false, is beginning July 1st, 2022, a person may keep $130,000 of their own assets and still receive Medi-Cal. This is a big change, but the answer is yes. So you may have heard of Assembly Bill 133. It was passed last year and it's going into effect in this regard on July 1st. It will allow the person, we're not talking about the spouse here. We'll talk about the spouse in a second. But the person actually receiving Medi-Cal, right at this moment, that person is limited to having $2,000 in cash. They can have other things like the one home, like we talked about, and other exempt assets, but $2,000 in cash in the bank. And July 1, that will change to $130,000. That's a big change. So, and if they are married and they have a well spouse who's not going to be receiving Medi-Cal, that spouse can keep, and this number goes up every year, so it's going to be a little confusing while it's similar right now, but they can keep, as of 2022, $137,400. So if you're good at math, you or even me, you can add those two numbers and see that a married couple could keep $267,000 and still have one of them go on Medi-Cal benefits, be in a skilled nursing facility on a Medi-Cal in a Medi-Cal bed. So this is a big change. Also, the spouse at home, if they're married, is entitled to keep entitled to have up to $3,435 of income. And if they don't have that on their own, they can some of the income of the spouse who's receiving Medi-Cal can be shifted over for the spouse at home to keep up to that amount. So that's also a number that's important to know. Similar, and Maureen did mention that I'm accredited by the Veterans Administration, so I can talk about this stuff similar to Medi-Cal, but very different because it's a federal program and only a federal program, and so the difference are different. The rules are a little different. Is something called aid and attendance that you may have heard about it, and so married veterans age 65 plus who need assistance may be eligible for a tax-free VA pension of over $2,400 per month to reimburse medical and caregiving expenses. And the answer to this is true. So that benefit is often referred to as aid and attendance. It can be a big help. It's not like Medi-Cal in the sense that it doesn't just pay whatever the bill is and you pay your income into it. This is just it's a cash benefit back to help with unreimbursed medical and caregiving expenses that the veteran might be expending and going into savings each year. The technical term for it is VA Improved Pension, and there's some requirements, and they're listed on the screen there. And one of the big ones is they need to have had wartime experience or wartime service, and they needed at least 90 days of active duty. And as far as how much money they can have a home, but the cash is the same as the community spouse resource, the limit under Medi-Cal. So that's that $137,400 this year. And that's what the entire married couple. So they don't get to keep a separate $130,000. That's just a California Medi-Cal thing. But for the veterans, between them, the married couple can have this $137,400. So that can be a real help in closing the loop on how to pay for in-home care or assisted living. I should have mentioned with Medi-Cal, Medi-Cal does not pay right out of the box. It doesn't pay for assisted living. Long-term care Medi-Cal is for skilled nursing in California. There is something that's being piloted in some counties called the assisted living waiver, but it's not in our county. It's the closest counties are Kern and LA, and the wait lists are long. And there are a lot of requirements, a lot of limitations to the assisted living waiver. So it's best to just think of skilled nursing as really the place where someone might be eligible for Medi-Cal long-term care benefits. But with the VA approved pension, if you're a veteran or if the person who needs the assistance is a veteran, this may be a way to help close that loop and pay for assisted living or care when the costs are so high and continuing to go up.
Chris, can I ask you one question related to these
Sure.
two things, the Medi-Cal and VA? Because
Yeah.
it just came up today with somebody who lives alone. She lives by herself. She's 85, has no caregivers. She has $4,000 in the bank. So she doesn't qualify for Medi-Cal yet because she still has that $4,000. So we're trying to help her. So when we look at these allowances, is that amount, especially for either one of these, but for Medi-Cal especially, is that the total amount of all the resources they have? So if they own a house, they can only have, you know what I'm saying? Like, is it, they can own a house and still have $137,000 in spending somehow, like in the bank account, like now when that law changes July 1st? Or
So,
is that the house or not a house included, or how does that work?
Sure. I'm glad you asked that because I'm just kind of running through without feedback. So I appreciate it. So Medi-Cal, the rule would be for a single person after July 1, it'll be $130,000 in available resources. So cash basically in the bank. In addition to that is a pretty long list of exempt resources, and one home, one vehicle, personal property. Those types of things are exempt. For the person you just mentioned, there are a lot of ways that you can take that extra 2,000 that she has right now and use it for something that would be exempt. For instance, putting money toward cremation or something like that. I mean, there's ways to take that money off the table legitimately and allow her to very quickly qualify for Medi-Cal. So that's yeah.
But so someone like that, when we have, patients or people in our community, as of July 1st, now she would, with even that $4,000, now she could qualify for Medi-Cal.
Yep.
Okay, and still have that $4,000 and still qualify.
It's a big change, and
That's huge.
I could tell you, I couldn't begin to tell you how many people are in that in-between area. I hear so many people in the 50, 60,000 range. They've saved, but they've had to spend down, and they're there, and they think they have to get down to 2. And this is really good news that they don't. And I want to get the word out earlier because they don't have to get down to 50 or 60 either. Go ahead.
Yeah. No, I just think it helps some of our most vulnerable because they're on the edge. They can't afford care. They can't afford home, in-home caregiving. She's right on the edge right here, So she has her pension. All that comes in is $2,200 a month. Yep. That's what she lives on for everything. And she wants to leave $4,000. She doesn't want to use it because she wants to give it to her daughter when she dies.
I'm just throwing another idea out. If her daughter went as a joint tenant on her checking account, then Medi-Cal only looks at that as $2,000 of hers. Okay,
that's good to know. And that could be the case, and we don't know that.
Yeah.
Thank you for clarifying that. That's great.
There's a lot of, it's a minefield. A lot of attorneys don't do this type of planning because there are so many rules, but there's a lot of rules, a lot of exceptions, and it's really important to ask. So thank you for asking about those. Going back to the VA aid and attendance, I just want to point out what those wartime periods are, because I mentioned you had to be a veteran of a declared war. So this is the list. And it's really funny, when I first got into this, I didn't realize there were exact days. Obviously, Armistice Day is a obvious, one, and there's certain World War II, that would be Pearl Harbor Day, the day we entered World War II. But so there are actual days that if you were there, if you were part of the service on those days, then you qualify, and if not, you don't. One of the ones that's really interesting is during this 60s, let's see, right before the Vietnam era, we had the Bay of Pigs, and so there are some times that just, even though we had good, wonderful people serving, that wasn't a declared war, and so that service would not count just by itself. But a lot of those people were on during the Vietnam era. Interestingly, the dates for Vietnam are different depending on whether you were in or out of theater, but you can see those right there. So hopefully that's helpful. I see we have a little more time, so I'm going to throw a bonus question. It's kind of related to all of this. I just mentioned actually doing this, but there's exceptions and rules. So true or false, adding a name of a child or other family member to your assets is usually a good idea. And I'm going to call that false. False, but there's always exceptions. There's always reasons where you might want to do it. And one of those might be if you're qualifying for Medi-Cal and they look at only half the account if you put your daughter on. That would maybe be a good reason to do it. But we call this non-probate transfers because it happens by operation of law when someone dies. It's joint tenancy is the most common. You hear about that. It's anytime there's 2 people on an account, that's joint tenancy. 2 main types. We have married couple joint tenancy and non-spouse joint tenancy. For married couples, it's very, very common to both be on an account. It's similar to community property, not quite the same, but we don't need to get into those weeds. What it does is delays probate. So remember, we talked about probate and avoiding that, and especially if you're on Medi-Cal, not wanting to go to probate, it delays probate. It doesn't avoid it because at some point the second person on the account will pass away, and there's got to be a way to get, to the intended beneficiaries. But what I'm talking about here is non-spouse joint tenancy, putting a child on just as a matter of course to try to estate plan. There's a loss of control, there's creditor risks, there's possible tax disadvantages. And frankly, there's possible public benefit disqualification if the account was large enough. That's not a concern in the case of the person that Maureen mentioned. But if we were talking about $100,000 account and putting a child on, that would have an impact on benefits eligibility, at least for a period of time. So be very careful when you're adding another person to an account. It's a way to say, hey, I don't want to go see Chris, or I don't want to go see a lawyer. I get that. I understand, but very much. But the fact is that doing this can be dangerous. This is doing it yourself, and there can be consequences that people don't think about. Another way of non-probate transfer is beneficiary designation. So you'll see this on, of course, life insurance and retirement plans, annuities, other contracts or accounts. And that's very common, but be very careful when you do it for the same reason. You want to use caution. Bank accounts have what's called pay on death designations, or PODs. Investment accounts have transfer on death, or TOD. Real estate has something called a transfer on death deed. It comes with a lot of requirements and a lot of rules, but it's a way to just transfer a deed of property, real property, at your death. It was set to expire at January 1 of this year, and they did extend it with some additional rules for 10 more years. So we do have this, but it's something you want to talk to an attorney about to make sure it's done right. So that's just another bonus question to get people thinking, because oftentimes the first thing people think of, well, if I just add my kids to this account, it'll work out. But if your child, for instance, even if they're the most well-intended child, if they're ever sued, they're in an accident, anything like that, all of a sudden that puts those assets on the table, and you don't want to see that happen. So just think very carefully when you're doing estate planning. Yeah.
Chris, I have another couple of questions that came in from the queue. One of them says, somebody, I'm sorry if I missed it, but aside from the bank account, if you have a home, can you qualify for Medi-Cal? So let's say your income might be small and you have a home, but you still have a home. Can you still qualify?
Yes. So you're allowed to have one home
Okay.
of any value under current rules. California has not implemented a 2006 law that would impact that, but we haven't implemented it here yet. 49 states have, we haven't. So for right now, and just so I can tell you what the impact would be, there would be an equity cap. That's if they implement that law, probably of $750,000 of equity, but that may actually go up because a lot's changed since 2006. So, but there'll be some, so you couldn't have a $10 million home still gone Medi-Cal. But for right now, you can have a $10 million home and still go on Medi-Cal.
Oh, wow. Okay. And here's another question. What about the person with no assets, but they make too much to qualify for Medi-Cal per month? For instance, a couple who makes $4,000 per month, but one needs nursing home placement, but they can't afford it.
Okay. So if we're talking about there's community-based Medi-Cal, which I'm not going to get into here, except to say that there are some income limits. I get that. I understand. And there's all sorts of programs and variations that, and I would just talk to an eligibility worker about that. So, but I can tell the question is about long-term care, and there is no income limit on long-term care Medi-Cal. So, so the premise, I think, is wrong, that there's a limitation on what they can make. In fact, if you remember the slide where I said $3,400 can actually be shifted over to the well spouse. So of that, $4,000 in that example, over $3,400 can be moved to the spouse who would be staying home. And the share of costs, the amount that the spouse receiving Medi-Cal would have to pay in, would be a modest $500 or $600. So they could qualify, especially if they had no assets. The key is you've got to be eligible for skilled nursing in Ventura County or need that level of care.
Yeah. Yeah. Thank you both for who sent those questions, and feel free to answer questions because we're almost out of time. So continue along, Chris, but this has been really helpful. Oh yeah, there you go. We're on our last slide.
On the last slide. Well, I do want to say, and if any other questions come in, that's fine. But I do want to say, look, not every question is going to come to mind right now. And if you have a question you think of later tonight or some other time, you can call that number, 805-246-7272. Just call and say, hey, I was on that webinar and I'd like to have a consult, and I will be happy to meet with you by phone, by Zoom, in person. and go through what questions you might have. So just keep that in the back of your mind. Happy to do that. That's a service we provide. I want to get the word out about a lot of these things so that people understand them. And if there's work to be done, great. But if not, at least you have that information. Knowledge is power.
This has been so helpful. I mean, I'm in this, but you have information that I'm still like, oh, that was such great information. So
No.
I'm really thankful that all of you who were on could join us today. And Chris, that you were so willing to give your time up for us. It was really, really fabulous to hear. And I had no idea that job, I knew something with Medi-Cal was changing, but I didn't realize it was that much. It's so dramatic.
No.
And they're trying to figure out like the poor. But
Right.
I think they're trying to make it like in California, it's just so pricey. So anyway, that's new information that'll change a lot of people's lives. So
There's actually another part to AB 133 I'll just mention, and that is they want to do away with the income limit or the asset limit entirely. That's part of it, and it's supposed to go into effect, I think, January 1, 2024. But there's a catch. All of these changes have to be approved at the federal level by CMS, by the Centers for Medicare and Medicaid Services. So that change, the change for July 1 has been approved, but the other hasn't even been submitted for approval. So that's a big question mark, but that's the intent. That's the goal of the state at this point, is to make it so that you don't have those resource limits. Whether or not that's a good idea, that's another question, but it's, at least this change will help people in a very real way.
yeah, that's great. Thank you so much. Jeanette, did you have any other things to add?
No, just a fantastic presentation, Chris. Thank you so much. Thank you, Maureen, for your time with us. I'm just really grateful for the folks that were able to join this seminar, and also looking forward to having folks have access to it. The recording will be available on our website tomorrow. So I'll be sure to let folks know how to access it. Our next seminar is scheduled for May 19th. So look forward to hopefully seeing you all there. And thank you again, and have a great evening.
Thanks.
Thank you, and thanks to the Area Agency on Aging, because it's good work you guys do. So bless you guys.
Thank you.
Thanks so much.
Thank
All
you
right.
all
Bye.
again.
Bye-bye.
Bye-bye.